Welcome to the Migrant Center for Human Rights DreamWeek podcast series on advocating for equality and justice for immigrants under the Biden administration. My name is Sarah Ramey, and I'm an immigration attorney and the executive director at the Migrant Center for Human Rights, where we work to provide free and low-cost legal services to immigrants at the South Texas Detention Center in Pearsall, Texas. We present this program to you today as we welcome a new administration to support the positive steps that President Biden is taking and to call on him in Congress to address all important immigration matters for those living in our communities or seeking to immigrate to the U.S. A list of topics for today's podcast can be found in the description box. If you missed our podcast on asylum policy, border policy, detention policy, or interior enforcement, we encourage you to listen to the recording on our YouTube channel. These podcasts should help give you a background and orientation useful to analyzing the various executive actions and other measures the administration is taking. Today's podcast is intended to provide an overview of affirmative benefits, including issues such as DACA, TPS, citizenship, permanent residency for survivors of crime, and more. We will be discussing the Biden administration's recent action on these issues, as well as where the administration has so far been silent. It is our hope that you will feel encouraged to take action to ensure that no immigrant is left behind. DACA, or Deferred Action for Childhood Arrivals, under Trump was halted. This affected close to 700,000 individuals who had been brought to the United States as children and had lived here their whole lives. The Supreme Court ruled that the manner in which the Trump administration ended the DACA program was not lawful, and therefore DACA began again. However, the administration was not accepting new applications, and it took a subsequent court order to say that the administration must do so. There were an additional 66,000 people, individuals who were too young to have applied for DACA under the previous administration. On January 20th, Biden issued a memo to DHS indicating that the government should do everything possible to support the DACA program. However, DACA is a temporary grant. It is a deferred action grant for 2 years that is accompanied by a work permit. What this country needs is a DREAM Act, a pathway to citizenship. President Biden has introduced the U.S. Citizenship Act of 2021, not only for Dreamers, but for their parents that would have been covered under former President Obama's DAPA executive action, as well as for all individuals present in the United States as of January 1st, 2021. This act creates a pathway to citizenship for individuals after 5 years. They can apply for legal permanent residency or LPR status, and after 3 further years, they can apply to become a USC or U.S. citizen. Individuals in DACA, TPS, or agricultural worker status can immediately apply to become legal permanent residents without waiting the 5 years. This legislation also will allow for the spouses and children of legal permanent residents to be considered immediate relatives for visa processing. Thus, they will not be forced to wait in long lines for a visa to become available. A pathway to citizenship is supported by a vast majority of the public, as well as legal status for individuals in this country without documentation. We've provided a link to sign-on letter here for those who want to add their name to the call for comprehensive immigration reform. These links will be active by downloading the PowerPoint slides on the event page. A link to the event page can be found in the description box at the bottom of this YouTube video. Undocumented immigrants pay taxes in the amount of $528 million every day. It makes sense for everyone in this country to do everything we can to make this population's legal status reflect the reality of their participation in our communities. To pass this legislation in Congress, The Democrats will need all 50 members to support the bill. This would force a tie with Republicans if we assume that Republicans will not be on board with it. We do hope that our Republican colleagues, as well as all Democrat colleagues, will sign on to this legislation. Should there be a tie, Vice President Harris can take the tie-break vote in favor of this legislation. In the House of Representatives, the Democrats hold a majority that would allow for some wiggle room in terms of the votes needed to pass legislation. TPS is a designation that DHS, or the Department of Homeland Security, makes for individuals when their country is experiencing some form of armed conflict, natural disaster, or other extraordinary or temporary condition that would prevent their safe return and ability to reintegrate. This is a status that at most can be given for 18 months. However, it is renewable, and for many populations in the United States has been renewed for 10 or even sometimes 20 years. Former President Trump attempted to limit TPS by not renewing it for a number of populations, and Biden has effectively reversed that policy. We have signed on as the Migrant Center to a letter back in September urging the Biden administration to do so, and we are happy to see that TPS individuals are included in the legislation presented to Congress. However, it is important to consider the limitations of TPS. TPS has a specific designation date. If you did not arrive before this date, you are not covered by TPS. The same issues will apply to the current legislation. If you were not present in the United States on January 1st, you cannot get temporary protected status. We believe that Congress needs to create some form of subsidiary or complementary protection so that individuals who would fall under this classification can request protection with an immigration judge. Our current system with asylum, withholding of removal, and Convention Against Torture protection does not protect individuals who are fleeing general armed conflict, natural disasters, or other extraordinary conditions. Asylum, withholding of removal, and Convention Against Torture protection are more or less intended to be fairly permanent. The other limitation with TPS, of course, is that it is an executive action, and therefore we urge Congress to get legislation on the books so that this will not be a continuing issue for individuals who have passed a vast majority of their lives here in the United States, have U.S. citizen children, and have contributed to this country for a very long time. The other issue, as mentioned before, is the maximum 18 months term, and this is why we keep on going back and back and back, and this continuously takes time, energy, and money away from our government that could be spent in better places. The Supreme Court recently granted certiorari in the case of Sanchez v. Wolf. This is a case being appealed from the Third Circuit, where the Third Circuit stated that individuals with TPS have not been inspected and admitted under immigration law. Inspected and admitted is important because this allows individuals to adjust status to legal permanent residence if they, for example, marry a United States citizen, instead of needing to return to their home country, which is dangerous in many situations, and the consular process through an embassy abroad. The Sixth and Ninth Circuits have both said that a grant of TPS qualifies under the Immigration and Nationality Act as being inspected and admitted. However, the Third as well as the 11th have not. Stay tuned for more as the Supreme Court looks at this case. Turning now to Deferred Enforced Departure, or DED. This is similar as TPS, but is designated directly by the President. It also has work authorization and is set for a specific period of time. On January 19th, former President Trump issued a memorandum directing DHS and DOS, Department of State, to defer the removal of Venezuelans. A new president has taken a step further and extended the status of DED for Liberians who, due to congressional action, are now eligible to get legal permanent residency, but have basically run out of time. Since 2007, when former President Bush issued DED for this population that had originally been granted TPS, it has been extended by former President Biden, former President Trump, all the way until January 10th, at which point this status lapsed. The Migrant Center has also called for support for a continuation of DED for both of these populations. And so we are pleased to see that we are on the right track in this regard. Turning to the issue of citizenship and the census, former President Trump issued 2 executive orders, first attempting to ask about citizenship status in the census, and this was struck down by the Supreme Court. He then attempted to exclude the individuals that were estimated or considered to likely be undocumented from the overall census count. However, the Constitution says that the whole person of the state must be counted. And while this has been under litigation, on January 20th, President Biden issued an executive order revoking the presidential memorandum. And now we are not excluding undocumented immigrants from the apportionment base. So this is the number that is used to apportion the House of Representatives members. And so this would have effectively taken away the number of members of the House of Representatives in a significant quantity from California as well as Texas and other places around the country. The legislation introduced in Congress is also moving to eliminate the 3-year bar and the 10-year bar. So under the 1996 Illegal Immigration Reform and Immigrant Responsibility Act, if an individual is here in the United States in unlawful status, meaning that they entered without documents or that they overstayed a visa for more than 180 days, they will not be able to apply for legal permanent residency for 3 years. 3 years that must be served outside the country. They stayed here in unlawful status for more than 1 year, they must wait 10 years outside the country. This is an issue because with the consular process, individuals who have entered without inspection must go back and wait and be separated from their families. There is a waiver for spouse and children of U.S. citizens or legal permanent residents, but only if they can prove extreme hardship. And so this bill, it will revoke both of these bars, thereby allowing individuals who have a legal path to staying in the United States to pursue that legal path, regardless of their unlawful presence in the U.S. We have several different forms of protection for victims of crime. We have the Violence Against Women Act, which protects victims of domestic violence at the hands of U.S. citizen or legal permanent residents, trafficking visas, and protection for domestic violence committed outside the country in the form of asylum. This last has definitely been limited under the past administration, primarily through matter of AB issued by the Attorney General, and we encourage you to tune into our podcast on asylum policy for more on this. You can also read our op-ed where we call on Congress to clearly delineate domestic violence victims as deserving of protection under our asylum law. We'll be focusing now on the U visa. The U visa has 2 purposes. It's to increase safety of our communities by encouraging undocumented immigrants to report crimes and assist in law enforcement investigations and prosecutions, as well as a form of humanitarian protection for these individuals who are often threatened with deportation and because they've reported, and also who have gone through horrible experiences here in the United States. We are calling on Congress to expand the categories of crimes protected under the U visa, as well as add testifying witnesses who are not direct victims. Testifying witnesses in federal crimes can qualify for S visas, but they cannot qualify for if they are witnesses in any state crime. And so this is an important way that we can further encourage the evidence that is needed to get criminal convictions accomplished by getting these testifying witnesses into court. The U visa has an annual cap of 10,000, and the legislation proposed to Congress is going to raise that to 30,000. This is a very positive step, but it is not enough. The cap should be eliminated. We have close to 130,000 pending applications right now. That's not including derivative children or spouses. And the backlog at the moment, therefore, is about 13 years. The current legislation would cut that down, but people would still be looking at about 5 years before they would get their visa. And this discourages people from going through the process, because nothing about being in the process halts someone's deportation. The system has established a wait list, and this is basically where USCIS looks through the petition, says we think it's approvable, but there's no visa available. So we'll put you on a wait list, and we'll grant you deferred action, so ICE should not deport you, and we'll give you a work permit. Unfortunately, the wait list is all but invalid, or has been in the last several years. There are individuals that we've worked with at the Migrant Center who have pending petitions since 2016 who have not been put on the wait list yet. And the Fourth Circuit recently found that the plaintiffs had pled sufficient facts to allege a plausible claim that DHS unreasonably delayed adjudication of their claims for placement on the wait list. This case has been remanded for further consideration, and this is just one piece of evidence that shows that these wait times are in fact unreasonable. So we're calling on the administration to hire additional staff to make sure that these cases can get processed quickly. Those who can get visas currently get those as soon as possible, and those who can't can get on the wait list. Basically, a number of people over the last couple years have been picked up by ICE and placed in detention centers and deported because their case was pending. It is called a U visa or U non-immigrant status for those here in the U.S. because it is a visa if you're outside of the U.S. It still is a pathway to coming back to the U.S. But of course, the challenges there are individuals are going to be separated from U.S. citizen children. They're going to be potentially removed to countries that are experiencing high levels of poverty. There's a lot of reason why it doesn't make sense to wait outside the country. And in fact, we're calling for those who are outside the country but have pending U visas to be paroled into the United States. That can be done under 214D2. So for cases that are in removal proceedings, we're calling on the judges to be able to grant administrative closure. That may require a change in Attorney General case law under matter of Castor Tum or congressional action to specifically carve out an exception for crime victims. For those who still need to file a U visa application, that judges grant continuances for good cause. For them to do that, again, that is going to require going back and changing some of what the Trump administration has done through regulation making. And at the bottom line, not detained people. I mean, unless they're a high danger to the community, someone with a serious criminal history, in which case they're likely to be denied a U visa, those individuals not be detained. There's no reason we need to stock our detention facilities with more bodies, right? These are human beings that have a right and a reason to stay with their families and communities. We are also calling on the expedited processing of deferred action in these cases. In fact, ICE can grant deferred action directly, but if the government does not want to do that, then we can certainly get these cases moving quicker. So we're calling on the administration to revoke the April 2019 fact sheet and reinstate the 2009 policy that required ICE to request prima facie determinations from USCIS. So effectively to put them on the wait list, jump them through the line to the front so that they could not be placed in removal proceedings or deported in the interim. And then, of course, hire more adjudicators. So American Immigration Lawyers Association is suggesting 60 to 80 more adjudicators. I think that's a good start, and we can revisit that later. I'm not sure if that's going to be enough, to be honest, but that would be a good start. Just one quick note, we are terming this part of the presentation crime victims because that is the general term used, but we prefer the term at the Migrant Center crime survivors. These individuals can be very resilient, and we don't believe that's useful to focus on the fact that they have been victims, but on the fact that they have survived that and are moving forward with their lives. Health insurance. So the Trump administration took many steps to limit immigration across the board. And one of those was to require that individuals either have health insurance or would be able to obtain coverage within 30 days or otherwise prove that they can pay for any potential medical bills. The Ninth Circuit recently, on the 31st of December, voted 2-1 in favor of upholding this health insurance requirement. So this is currently the state of the law. On the flip side, Trump's public charge rule has been struck down. So Trump redefined the definition of public charge. If you are a public charge, you are not eligible to get a green card. You're not eligible to just status or consular process for a legal permanent residency. And this means someone who is a public charge, of course, but also someone who's likely to become a public charge. And so this definition was expanded fairly widely to capture many more people. And on November 2nd, a district court vacated the public charge rule, finding that it was a violation of the Administrative Procedures Act for being arbitrary and capricious, and exceeded DHS's authority, etc. The Ninth Circuit has also held the same, but limited that ruling to the Ninth Circuit. So between these two, of course, the country is covered, and this rule is currently on hold, but the litigation is continuing, and the Biden administration should certainly step in and get us back on the right track. There has been overall a slowdown in case processing of about 46% under the last administration, and this has created a huge backlog in cases. This is a slowdown that was prior to COVID, right? And is a slowdown that has nothing to do with the number of cases filed. The cases filed has not gone up. The reason why the processing has gone slower is because some of USCIS money has been transferred to enforcement away from adjudicating cases. And there's also an increase in fraud investigations and interviews within USCIS under current policy. So this is all something that the Biden administration should sit down and study and revisit, and speak with stakeholders on, so that we can get to a place where our government is functioning effectively. In fact, the fall of last year, USCIS said that they would need to furlough 13,000 workers because of budget shortfalls, even though their budget actually showed that there would be a surplus, at least in the short term. And Congress got USCIS out of this situation, but there was talk at the time that this issue would be coming back again in the new year. So there likely is again a need at the present moment to look at this and make sure that we have proper funding in place. The administration also tried to increase filing fees, in some cases doubling the cost, for example, to become a U.S. citizen, charging for asylum for the first time ever, make us one of only 4 countries in the world to do so, and basically creating an extra burden or an extra hurdle for people to legalize their status. There's ongoing litigation on this. These increases are currently not in force, but this is another issue to stay, in touch on. USCIS needs to reestablish itself as a customer service agency, right? It's not a law enforcement agency. It exists to process petitions and assist the people who are applying. USCIS changed their mission statement under the Trump administration by taking out the language that we are a nation of immigrants, and we are calling on the Biden administration to get that language back in there, not in the first 30 days. I mean, there's no reason that we need to wait 100 days. In fact, we could probably get back to normal on this next week. So very easy thing to fix. Sends a strong signal that we want to work with immigrants and that we're open to discussing and their situation, and acknowledging that in many ways the vast majority of us are immigrants or have been at some point in our family history. The legislation being introduced by the Biden administration will increase diversity visas from 55,000 to 80,000. Diversity visas are visas that are handed out not exactly at random, but to countries around the world to increase the diversity of the population in the U.S. So under the last administration, legal immigration, because of all these reasons and more, has decreased by 50%. And the number of immigrants who have come to the U.S. as legal permanent residents has declined 13. So we've really seen a contraction. Specifically related to COVID, we've seen the administration try to block the entry of foreign workers coming on certain types of visas like the H-1B. That's for skilled workers. And also the administration moving to take away the student visas for students who began to take online classes. There was a big outcry by a lot of universities around the country, and the administration eventually pulled back and rescinded this policy. Of course, it would not make sense to force students to transfer to other universities where they couldn't get the same degree, or to go back to their countries where they'd be on a completely different time zone and might not be able to attend classes, even if those classes were offered online. So fortunately, that has been resolved. The other thing, or one of the other things that the Trump administration, of course, did right from the very beginning in 2017 was to introduce a travel ban on individuals from certain countries, the majority Muslim. And this is also, of course, called the Muslim ban. It was a series of 4 different executive actions that effectively covered 13 countries, and it was upheld by the Supreme Court in 2018. And turning to our next slide, this has been rescinded. So one of the very first things that President Biden did was rescind all 4 of these travel bans, or Muslim bans, also known as African bans, and has required DOS, Department of State, to provide expeditious service for adjudication of visas, including the ones that were previously denied, to study this process, and especially with regards to vetting and screening of cases, and information sharing and use of social media to ensure that we're safely and accurately processing cases. The administration also has put forward a moratorium on all the notices of proposed rulemaking. So all the consideration of the public comments that we have submitted as the Migrant Center for Human Rights and as you, the public, those are not going to be looked at. They're not going to be considered until the administration steps back and says, okay, well, do we want to move forward with redacting a rule on these particular issues? So stay tuned in the next couple of weeks on that. There are still some important proposed regulations out there, including those on continuances and motions to reopen and reconsider and stays of removal. Work permits. Again, the Trump administration attempted in several different ways to limit access to work permits. So one thing, just as an example of what the administration did, they moved this eligibility for a work permit for asylum seekers who have filed an application from 180 days to 365 days. The idea here is that if an asylum seeker has filed an application and it's the government's fault that they're not processing that application quickly, the asylum seeker should be able to work in the interim. Right? They shouldn't be forced into a situation of poverty or relying on relatives simply because the government is slowly adjudicating their case. This rule has been struck down. There's a preliminary injunction in place. You can read more about that on the slide here. The administration also issued a notice of proposed rulemaking to take away work permits with few exceptions for those on final orders of removal. These are individuals where the government can't effectively deport someone because our country won't take them back. We have a podcast on this issue as well as a public comment we submitted that you can listen to or read for further information. And with that, we conclude our DreamWeek morning podcast series. Thank you so much for tuning in. Please do visit our event site if you would like to receive any more information on any of the topics from this series. A link to all of our YouTube videos is there. You can also, of course, go to our YouTube page to access those podcasts directly. Please stay in touch. Sign up for our newsletter if you'd like to get updates on what is happening in the news and what the Migrant Center is working on. And of course, feel free to check out our job and volunteer postings and learn more about our work. Thank you again for tuning in and have a wonderful day.